I've been doing access to justice work for the better part of my career, Judge, and I've never heard an analysis as insightful as yours, and I can't think of a better segue to our next panel, and I'm going to ask our Right to Counsel panel to come up, because our next panel is going to talk about right to counsel in just one important area of civil law, that is eviction cases. So on to that. All right. Well, again, thank you all for being here. I'm Ron Flagg, President of Legal Services Corporation. And as I said a moment ago, our panel today is going to talk about the one area of civil law where legislatures, state legislatures, city councils, county supervisors have deemed it important enough to provide right to counsel, and that is in eviction cases. And let me provide a little context for that. Let's go back to the good old days prior to the pandemic. In the good old days prior to the pandemic, the annual eviction rate in the United States, I believe in 2018, was 3.6 million evictions. And of course, if we're talking about 3.6 million evictions, we're talking many more millions of seniors and children, all wrapped up in those evictions. And when we talk about evictions, we're not just talking about people losing their homes. We're talking about people losing access to their jobs, to their children's schools, to health care. We're talking about family arrangements disrupted. So losing your home, as Chief Judge Wilson suggested, is far worse than even a short stay in jail, and can really be a lifetime sentence of misery for those involved. So that's the good old days prior to the pandemic. Then we go to the pandemic, and in 2020, at the outset of the pandemic, up to 30% of America's renters face the risk of losing their homes because of the spike in unemployment that occurred at the outset of the pandemic. And fortunately, the government responded, both federal, here in New York State, local governments, but across the country. And we had moratoria, and we had emergency rental assistance, federally funded, $46 billion. And so fortunately, the tsunami of evictions that we feared did not occur, at least not fully, in the immediate wake of the pandemic. But of course, those things have all gone away. The eviction moratoria are largely expired, and the emergency rental assistance is now dwindled in most places to nothing. And so we really face another crisis, continuation of the eviction crisis that we've faced now for many years. And up to 20% of America's renters face potential eviction. Given the gravity of evictions, given the volume of evictions, a number of jurisdictions, I believe it's 5 states and 18 local governments, have enacted right to counsel laws across the country. And we have the opportunity today to talk about how those arose and how they're going in 3 places: New York City, Newark, and Kansas City. And we've got 3 different perspectives from each of those communities to be shared with us. And now it's my privilege to introduce my colleagues from next to me to farthest away, Kabira Myers, who is the coordinator for the Office of Tenant Legal Services in the city of Newark. And from Kansas City, we have, or the Kansas City metropolitan area, we have the Honorable Dennis Eckhold, who is on the 6th District Court there. And next to Judge Eckhold, we have Ron Rasmussen, who's the Executive Director of Legal Services of New York City, which is the single largest legal aid program in America. And I'm just honored to have all three of them here with me today. So I'd like to start by asking sort of how your right to counsel laws originated. Two of them originated prior to the pandemic, one after the pandemic rolled out, and sort of what the who was responsible for advocating for them and what they entail. So Ron, New York City's right to counsel law, I think, goes back to 2017, and as such, you're our senior panel member.
Great. I'm happy to start. Is this on?
Yep.
Yes. Okay, great. So New York City has a long, strong history of tenant activism, of tenant organizing, and of legal services, lawyers and legal services programs working very closely with those tenant activists and organizers. And for the 50 years that Housing Court has existed in New York City, we have been pushing very hard to expose all the bad things that happen there and to fight against the bad things that happen there. And we know that when tenants are threatened with eviction, first, they're threatened. And they're threatened with the loss of their homes and the fear about what that means for their families and their children. Then they go to Housing Court, and they stand in long lines because they're in a poor person's court that's badly funded and that doesn't have enough staff to support the kind of processing of cases that occurs in federal court. Anyone who's ever been there did not stand in a long line and did not see long lines of people, mostly black and brown, on the streets outside of the courts, waiting for an hour or more to get into the court and to be filled with fear while they waited that their cases were going to be called, they were going to be defaulted, and they were going to lose their apartments without ever having made it into the building. So for the entire history of the Housing Court, we have been pushing hard to fight against the way Housing Court is processed, but also to ask and to demand that a right to a lawyer be appointed for tenants who are in Housing Court. Because we know during the entire history of Housing Court, 90% of landlords have lawyers, 10% of tenants at most have lawyers. And so fast forward up to 2014, the Right to Counsel Coalition formed, which is a coalition of tenant-based community organizations and tenant organizers and legal services programs. A law was drafted then and pushed for the next 3 years very hard by the Right to Counsel Coalition. And in 2017, in August of 2017, the first right to counsel law in the country was adopted by a progressive city council and mayor. And we've been working since that time to implement that law. That law provides for a right to a lawyer for tenants who are being sued in Housing Court who have incomes under 200% of the federal poverty level, which is about $60,000 for a family of four. And any tenant who comes in is entitled to that lawyer, but unfortunately, and we'll talk about this in a little bit, there aren't enough lawyers to go around just yet.
You mentioned the 90% representation rate for landlords and 10% for tenants, and that holds true across the country. That's generally the breakdown we see across the country, where you have historically, 90% or more landlords represented and 10% or fewer tenants, and it makes a difference. Again, if you look across the data nationwide, basically, if you don't have a lawyer in eviction court, you lose your home. Maybe you even default, or often you default. If you have a lawyer, on average, you win. You stay in your home. You are able to stay longer than you otherwise would have. So it's really a dispositive factor as to whether or not you have counsel. Kabira, Newark was just a year later in terms of right to counsel. Can you tell us how it arose and sort of what the outlines of the program are?
Absolutely. And good afternoon, everyone. And first of all, I would like to thank Legal Services Corporation for this opportunity. This is tremendous. I'm extremely honored to be amongst everyone here. I'd also like to thank the Ford Foundation for allowing us to use this absolutely beautiful facility and for its support for pro bono attorneys and legislation. So if I could just give some background about the City of Newark's quote-unquote right to counsel legislation and the office that I run, around 2018, Newark Mayor Ras Baraka introduced a multi-layered blueprint for equitable growth and housing stability in the City of Newark. One layer of that blueprint was the introduction of right to counsel legislation and an associated office to implement and uphold that legislation. So thankfully, in 2018, the Newark City Council passed that right to counsel legislation. Shortly thereafter, I was offered to run the office called the Office of Tenant Legal Services. And I also want to thank the City of New York for being the harbinger, right? You guys are amazing. When our legislation was introduced, Mayor de Blasio came down to the City of Newark and joined us in announcing to the public that we have this right to counsel legislation that we would like to get passed. And I think that it's because of your support that we have the right to counsel legislation that we have now in the City of Newark. So similar to the eligibility criteria of New York, the City of Newark's Office of Tenant Legal Services has eligibility criteria. We only provide defense attorneys to Newark tenants whose household income does not surpass 200% of the current federal poverty level. And we do make exception for seniors, people who are over the age of 60 and infirm. And so again, this is, this office that I run is a product of a progressive mayor, Mayor Baraka, who had the vision and the foresight to introduce this type of right to counsel legislation, because the City of Newark, if I could just say really quickly, and I could go on, Mr. Flagg, so please cut me off. I'm very, very passionate about right to counsel in the evictions landscape. The City
Why?
of Newark, housing is everything. If you don't have a home, you pretty much don't have much of anything else. And mental health and housing are symbiotic, right? So you can't upkeep your mental health if you don't have a home. If you don't have a home, then whatever mental health disabilities you might have is exacerbated. And so housing is everything. It really is. I could keep going about that. But the City of Newark is a municipality of tenants, right? So the City of Newark has about 300,000 residents, about 80% of which are tenants, the majority of whom are rent burdened. And I think that everyone in this audience knows what that means, right? Like you're spending more than 30% of your household income on rent, which means that the majority of Newark residents are susceptible to the threat of eviction. They're facing the threat of eviction. So that was part of the reason why Mayor Baraka had the foresight to, to make this happen, this right to counsel happen in the City of Newark. Thank you so much.
Thanks a lot. So let's move forward 4 years. We're now in the pandemic, and these right to counsel laws, which in a couple of instances arose here on the East Coast in the New York metropolitan area, are now sprouting up in other places, Cleveland, Kansas City. Judge Eckold, how did the program arise in Kansas City, and sort of what are the outlines of it?
Well, first of all, I'd like to also say thank you for having me. I always wonder how it is I end up in some place or in a particular job, and Where's Waldo is one of those things. But I will tell you that we have a saying back home: everything is up to date in Kansas City, and I think we're getting there. The City Council in December of 2021 passed the right to counsel And there was a group, the KC Tenants Group, which was very vocal, would go to the city council meetings consistently, and eventually that ordinance was passed. So I worked in a state court, and we had a city ordinance that was going to tell all of us in state court that we needed to advise people of right to counsel in eviction cases. And I did that, and I would see it on the screen. I could tell whether somebody was a Kansas City resident or not. Kansas City is unique. It's 319 square miles. It's in 4 different counties. So the lawyers that would be working, such as for Legal Aid of Western Missouri, they would have to go to 4 different state courts to represent clients in those courts. I was one of those courts in Platte County, and we have about 115,000 residents there. Kansas City's about 500,000. They funded the program in effectively June of last year, $2.5 million, and it's part of the regular city budget now.
So let me stick with you, and the question that I'm sure comes to all of us is how are these programs working? I mean, the theory is if you don't have a lawyer, you lose, and having a lawyer is going to make a difference. You have really a unique perspective. You saw it from the bench. So how was the program working from that perspective?
Sure. Well, the first thing I would start the docket. I'd have a docket of 80 to 100 cases on a Tuesday morning, followed by trials, usually on the heels of that docket, knowing that I had a criminal docket starting at 1:30. So, and you remember how difficult that can be, and it's stressful. But we would get through it. An attorney from Legal Aid of Western Missouri would make an announcement at the beginning of the docket about the program, and I permitted that. I thought it was appropriate for them to be able to do that. And then somewhere in the middle of the docket, somebody might not realize that they had right to counsel, and I could see it that they did, and so I wanted to make sure that they had the opportunity. Missouri's statutes are very skewed toward landlords. So in Missouri, somebody can take a judgment after service of process has taken place at least 4 days prior to court. And then if the matter is not resolved on the date of court, I have to put it on an accelerated docket, which means 1 or 2 weeks later. So that made it very difficult for people to seek counsel. So I wanted to make sure that they had an opportunity. But it did work well. The folks at Legal Aid provided me with some information. The last year we had, she told me, the executive director indicated that they had 1,330 people that they had represented. 1,157 of those folks were able to stay in their homes, and they were able to, there was either dismissal or a judgment signed, but the matters were resolved. And so it has done very well. And it also would wipe out my trial docket. Because I would say, okay, where are we at with this? And they'd say, Judge, we've gotten it resolved, and it was great.
Well, and that's terrific. And I mean, again, these numbers are sometimes numbing. 3.6 million evictions, 1,100 people or 1,100 cases resolved with tenants in their home. I mean, that's first of all, it's not just one person. It's typically 2 or 5. And it's not just staying in your home, but meaning you can get your job, your child can stay in school, they don't have to change doctors, so it's really a life-saving event. Ron, how have things gone? Has it made a difference here in New York City? What's your observation?
It makes a huge difference. People who are represented don't get evicted, by and large. 85 to 95%, I would say, of the time, people do not get evicted. The challenge now is that there are about 170,000 active cases in the New York City housing courts, and only about 30% of those are being assigned lawyers at the moment. So we have a program that we know works, but it's a challenge to build it up to the point where we can actually provide counsel for every single tenant who's entitled to one. So people don't get evicted. They don't have to go to court as often, and so, as you say, they don't lose their jobs or lose their pay. When they come to court, they have someone to talk to, someone who can stand up for them, during the process of which they also learn about how they can stand up to their landlord, what their rights are, how they can stand up to their landlords, how they can stand up to their landlord's lawyers. Because one of the things that happens in housing court repeatedly, unfortunately, is that not only are people abused by the whole process, they're abused by landlord attorneys and by their landlords, sometimes, I'm sorry to say, by judges, not that often, fortunately. But so the whole process is demeaning and dehumanizing, and when there's a lawyer by your side, that doesn't have to happen. So it makes a huge difference. It also, having a larger number of lawyers working on behalf of tenants in the courts, allow us to take on and challenge and expose the racist and sexist behavior of landlord attorneys, which occurs all too often, and sometimes court personnel. So there are a lot of positive impacts of a right to counsel program that go beyond the most important impact, which is that people don't lose their homes.
Kabira,
Yeah,
the Office of Tenant Legal Services, so I think you have a good perspective on this as well. What does this look like? How is it working in Newark?
So definitely the fact that we're able to represent more Newark tenants, that, more Newark tenants have attorneys to represent them and provide them with legal assistance when they're facing a threat of eviction has had an impact. Unfortunately, we don't have enough attorneys to represent every tenant that receives assistance from our office, but we turn no tenant away. And frequently, even if we're not able to represent a tenant, we're able to give them, our attorneys are able to give them enough information to represent themselves in court to stave off, their eviction. I also have to say that the existence of our office has a lot of residual benefits, right? Like there's greater collaboration between the judiciary and the tenant advocate community now, since the inception of my office, than prior to. And that's key. Collaboration between the judiciary and the tenant advocacy community is so key to ensuring an effective right to counsel, legislation and office, pro bono legislation, pro bono office, I should say, for tenants facing eviction. That is so key, that level of collaboration. So we're definitely seeing a lot more of that. And we're also creating more of a presence throughout not just the city of Newark, but throughout the state of New Jersey. The tenant advocate community has more of a presence since the introduction of my office in the city of Newark. So it's been pretty beneficial, pretty exciting.
So this is a very tantalizing situation. We have a problem, evictions. The problem is actually precedes evictions. It's a lack of affordable housing, and it's connected ultimately to evictions. We know that if people get a fair shake and they have a lawyer, that they can assert rights and defenses that they have, and absent a lawyer, they lose. We know all that, but sometimes we don't have the funding. Sometimes we don't have the ability to hire enough lawyers, even if we have the funding. Ron, I know you and a couple of other legal aid leaders here in New York wrote an op-ed back in April of this year pointing these things out and really calling for more funding, and you did get another, I believe, $20 million, which, again, $20 million, don't think about it, the $20 million, think about the tens of thousands of people who will probably, as a result of that $20 million, stay in their home. Kabira, let's just stick with you for a moment. How is the funding? How is the availability of lawyers in terms of getting enough lawyers, even if you had the money? And also, are you getting pushback from, landlords or landlord, organizations?
100% to the latter. We get angry landlords calling our office at least monthly. You know, they don't seem to think that it's fair that tenants get free lawyers in landlord-tenant court, and landlords don't get free lawyers. And they seem to be ignoring the reality that the majority, you know, at least 90% of landlords represented in landlord-tenant court in New Jersey are represented by counsel, whereas the reverse is the reality for tenants. You know, at least about 90% of tenants facing eviction in landlord-tenant court in New Jersey are not represented by an attorney. So there's a huge power imbalance just starting there. But the challenges are never ending, one of which is recruitment. It's always been a challenge to recruit attorneys who have an interest in this type of law. And it takes a certain type of attorney to do this type of work because it is incredibly challenging. You have to be very passionate about social justice and social justice issues because you will be constantly met with opposition, challenges, and firms that are adversarial firms that are better funded than yours. So that's always a challenge. I would say that for my office, recruitment is probably more challenging than funding. And if we could just get more attorneys who have an interest in this type of work, I think that it would be a tremendous difference. Another challenge that we face regularly is tenants not coming and seeking assistance timely. That's been a challenge since inception. It's a challenge more so now, I would say post-pandemic, and I think that has to do with the speed at which eviction cases in my county, the County of Essex, are going through the judicial calendar. We frequently see tenants that are coming seeking assistance post-judgment. Or literally the day before they're being locked out. And I think part of that is service of process phenomena, and issues, which has been an issue in my county pre-pandemic. It continues to be an issue. Many tenants are not being timely served with trial notices, unfortunately. And if you're not being timely served with trial notice, then you're more likely to be defaulted, right? And so oftentimes, we're servicing tenants who, have been defaulted in court. So that's a huge challenge as well. Ensuring that, tenants receive proper notice, timely notice, and also, that they receive notification about our existence. Frequently we hear tenants telling us that they didn't know that we existed until the last minute, until they went to court. And I do have to, applaud the judiciary of the state of New Jersey because they do make a robust effort to inform the community about offices like ours, as well as legal services offices. So that's been great, but frequently tenants don't learn about our existence until they go to court. And so that's a challenge as well, because I think we can all agree that it's better to be proactive, rather than trying to put a Band-Aid on something that is already, when the damage has already been done. So I could keep going, but I know we only have 30 minutes.
Just you've included a lot of points which are worthy of a quick elaboration. You mentioned the differences in, even within New Jersey, different jurisdictions have different rules and regulations applying to evictions. And this is true across the country. Within states, across states, LSC is currently doing an eviction study that should come out within the next year that's going to talk about that. And there are vast differences. It costs a few dollars to file an eviction in some jurisdictions and hundreds of dollars in other jurisdictions. In some jurisdictions, you can be evicted within a couple days of getting notice. In other jurisdictions, 30 days. Those differences have to have an impact on eviction rates. You know, I don't know to what extent that lawmakers take those differences into account when they're making these laws. The other thing you mentioned is recruiting. And again, across the country, legal aid lawyers are the lowest paid legal professionals as a category, lower even than public defenders and obviously lower than other categories of lawyers. So it's a challenge. Judge Eckold, how have things gone? What barriers? And I know your program is still newish, but what have you been seeing in Kansas City in that regard?
One of the things I failed to mention is there's no income restriction with the Kansas City ordinance. So it's open to anybody who's facing eviction, although I assume and I think that by and large it's being used by the people who really need it. And the biggest problem is, just as everyone up here has mentioned, is the lack of counsel. And so that's the biggest hurdle for those for legal aid. There are 3 organizations in Kansas City that provide attorneys, the largest one being Legal Aid of Western Missouri. The University of Missouri, Kansas City fellowship program provides attorneys, I think not very many, but they do provide some. And then one other organization, Heartland, is another organization that provides an attorney or two. So yeah, that's their biggest hurdle.
Ron, how about, what are you seeing here, both in terms of funding and hiring enough attorneys and any other,
Sure.
barriers?
So in New York City right now, the annual filing rates are approximately 120,000 cases. Of those 120,000 cases, we calculate that roughly 75,000 are eligible to have a lawyer assigned to them. But at the moment, the city's only contracting with the legal aid community to provide 35,000 of those cases. So far less than half the need. And they're paying badly for the services that they're contracting with us to do. So, for example, we have a $30 million contract. Legal Services NYC has a $30 million contract with New York City to provide right to counsel services. We're spending $45 million to implement that contract, and we still don't have enough staff to meet the contractual demands. So we are fighting for funding fairness in all of our city contracts. We're also fighting for additional funding to get us all with contracts that would allow us to serve the 75,000 tenants who are eligible for our services. And recruiting and retention are huge challenges. There were huge challenges that started particularly during COVID. We had at one point roughly a 33% attrition rate, which meant for our staff of housing lawyers of 150, we were losing between 30 and 50 lawyers a year. Every time someone leaves, their full caseload has to be handed over to someone who's already on staff, which means that now they can't take a new case. So there's huge logistical problems in building a program the size that is needed to address the need in whatever jurisdiction we're in.
So a number of these right to counsel laws come as a package with other measures such as eviction diversion, mandatory mediation, availability of other services. Judge Eckold, I don't know to what extent that's the case in Kansas City. What do you think would be helpful in dealing with housing issues, beyond or in addition to the right to counsel?
Well, let me just say that cities seem to be the leaders in so many things, when it's right to counsel, whether it's climate action planning, gun control, and so it's a blessing that at least 22 jurisdictions or cities now have right to counsel. It's
Amen.
Yeah, and so you know, and it's so incredibly important. I mean, you think about the most prominent case in on my landlord-tenant docket was a single-parent family. And you can imagine the eviction process and what impact it has on the children and their futures. And so just gathering data, the data that they already have gathered thus far is good. Hopefully the funding will improve. You know, it's budgeted for next year, and so things are looking up.
Kabira, what's your final observations in this?
So I have a lot of observations, and again, I know that we're only limited to 30 minutes. I do know that one of the topics that we were asked to discuss was some recommendations for folks who are interested in right to counsel legislation themselves. And one of the things that I would encourage you to do is look at your state constitution and look at your case law, because New Jersey has a consequence of magnitude doctrine that our Supreme Court introduced in the 70s, I believe it was in 1971, and it provides that if an indigent defendant in any type of case is facing a consequence of magnitude in that case, then a right to counsel is invoked. And it is because of that doctrine that we now have a right to counsel in adoption cases, right, in the state of New Jersey. And I think that will form the basis of right to counsel, you know, in eviction cases in the state of New Jersey as well. And a lot of our right to counsel advocates in New Jersey are actually pushing, you know, using that doctrine to push for right to counsel in eviction cases, because losing one's home is absolutely a consequence of magnitude. So another recommendation that I would have for pro bono attorneys in general is to take your time. Most of us are incredibly compassionate people, right? Like, I think most of us, at least those of us who've been doing this for a long time, are not in it for the money, but we're doing this type of work because we're passionate about the issues. It's not a job for us, it's social justice work. And with that comes the discipline to not react and want to help every indigent tenant that is coming to you with a lockout scheduled for tomorrow, right? Like, you know, ethically, you can't do that for every tenant that comes to your office. And I find that that's a challenge for myself every single day. I've been practicing law for almost 20 years. And that's still a challenge for me every day. But you have to set a boundary and tell yourself that investigation is an ethical requirement, right? Like, you can't represent someone or develop a theory of the case unless you're able to thoroughly investigate. I mean, the same principle holds for a medical doctor, right? You have to diagnose the patient. And so, you know, I find that that's a principle that I really have to follow in the political, you know, government context, because you have a lot of folks who, I'm going to try to measure my words. A lot of folks expect you to give on-the-spot assistance, right? And literally, like, you know, I guess, you know, they, you know, on the TV shows, you drop what you're doing, you show up in court at the drop of a hat, right? And so you have to exercise that discipline and, you know, set boundaries for those around you as well, because they will expect you to drop what you're doing. For example, the 82-year-old constituent tenant residing in subsidized housing who's going to be locked out pursuant to a warrant of removal tomorrow. But you've got maybe like 5 other open cases with similarly situated tenants. So you kind of have to be disciplined and triage yourself and, you know, and set boundaries. And it's not heartless to say that, unfortunately, I will not be able to go to court with that 82-year-old constituent because I have an open case, and, you know, and I'm responsible for that case first. So, you know, those are just some of the recommendations that I have, and I will.
Thanks so much. And you know, I think your first observation about the state constitution dovetails perfectly with the remarks of Chief Judge Wilson about constitutional interpretation. You know, these really are fundamental, if not rights, you know, fundamental human concerns. Ron, you get the final word.
So, final word, wow. Well, work really closely with tenant organizers and tenant associations and community-based organizations if you're going to build anything that is going to improve tenants' lives. Work really closely with the judiciary and city government if you're going to build a program that is going to last. Figure out how to balance the urgency of the need with the need to build a foundation for a program that can withstand the test of time. You can't hire 50 lawyers tomorrow unless you've already got 5 to 8 supervisors who are there waiting for 50 new lawyers who they can supervise, and that's hardly ever the case. And finally, although all this talk is about the importance of a right to counsel, don't let right to counsel funding suck the funding away from the other really critical housing work that needs to be done to address discrimination in our communities, to address landlords who are systematically illegally registering rents in the communities. There's a lot of systemic and system change-oriented work that needs to be done, that has to be done if we're going to build communities that are stable and that are integrated and where we're attacking discrimination. And if all of the funding is going to one after another after another after another of eviction defense cases, then we're gonna lose the battle over time. So right to counsel is critical, but don't let it suck all the money from all the other good stuff that has to be done.
With that, please join me in thanking our panel.